A will tells everyone what should happen to your money, possessions, and property after you die. In legal terms, we call all of those things together your estate. If you do not leave a will, then the law decides how your estate passes on, and that might not be in line with your wishes. Those laws are called the laws of intestacy. It is easy to make a will, and it will save your family and your loved ones unnecessary distress, which will be high at an already very difficult time. These are the main reasons to make a will. It will make it much easier for your family and friends to sort out everything when you die, and without a will, the process can be more time-consuming and more stressful. If you do not write a will, everything you own will be shared out in the standard way defined by the laws of intestacy, which is not always the way you might want. If your assets are very valuable, then the will can help reduce the amount of inheritance tax that your family will have to pay from your estate upon your death, and this will increase the amount of money you can leave to your family and friends. Writing a will is important if you have children or other family who depend on you financially, or if you want to leave something to people outside of your immediate family. It is particularly important to have a will if you are not married to your partner or the other parent of your children. They may not have any rights to make claims against your estate after your death, as the law of intestacy provides for your estate to be shared equally between your parents if you have not left a will leaving your estate to someone else. If you do have children, the estate will be shared equally between the children, but your partner would have no claim to your estate. You can express a wish in your will as to who you would like to look after your children after your death. This would be particularly helpful if the children do not see their other parent, and there may be circumstances where the children would be placed at risk of harm if the other parent cared for them, or the children may not know that other parent. You can therefore confirm in your will who you would like to be the guardian of the children upon your death. This is called an expression of your wish, and it is not legally binding. However, if court proceedings are required to determine where the children lived, the wish you have expressed in your will be considered by the judge in addition to all other factors that might affect the children, their welfare and best interests. Lasting powers of attorney. You can appoint someone to make decisions on your behalf in relation to your property and finances and/or your health and welfare in the event you no longer have the legal capacity to make those decisions yourself. The person you appoint is called an attorney. There is a general perception that lasting powers of attorney should be completed by older people who may be at risk of being diagnosed with dementia in later life. Everyone should think about appointing someone to make decisions on their behalf if they lose capacity. Younger people could lose capacity to make their own decisions. For example, they had an accident or an illness that resulted in a brain injury that affected their ability to make legal decisions. There are two types of lasting power of attorney. The first is a lasting power of attorney for property and finances. You would appoint at least one and up to 4 attorneys who would be able to make decisions in relation to your finances and property if you are not legally able to do so yourself. It would mean that those attorneys could withdraw money from your bank accounts and sell your property, but there are various protections in place. The second lasting power of attorney you can make is the health and welfare lasting power of attorney, and this would give the power to your attorney to make decisions, once you no longer have the capacity to do so, in relation to your medical care, whether you should be moved from home to a care home, or from one care home to another, or to a hospice. The attorney can make decisions on whether you should receive life-sustaining treatment, and they can also make decisions on your daily routine, for example, washing, dressing, and eating.